Dear friends and colleagues, hello from Canada. Let me start by expressing my heartfelt gratitude to the British Institute of International and Comparative Law for its very useful global toolbox on corporate climate litigation. Having reviewed the toolbox in depth, I can attest to the fact that it contains a wealth of information and insights that will be very useful to litigators, judges, and others going forward. And the timing could not be better. As everyone attending this launch is surely aware, we are in the midst of an unprecedented climate crisis that is already wreaking havoc on the lives of billions of people. In my work with the United Nations, I've met Fijian villagers forced to relocate because of rising sea levels, Sami people in Norway whose reindeer, the living heart of their culture and their economy, have been starving to death because of climate change. I've met farmers in the global south who told me that the heat is becoming unbearable for them to work in the field during the day. In Kenya, I met pastoralists whose cattle, their life savings, died because of unprecedented droughts. So people are turning to litigation in a desperate search for accountability and more urgent, ambitious climate action. Too many governments and too many businesses have ignored climate commitments, broken promises, and gotten away with it because of the lack of strong enforcement and accountability mechanisms in the Framework Convention on Climate Change and the Paris Agreement. So in recent years, we've witnessed a surge in climate change litigation with some truly historic victories. The Urgenda decision of the Supreme Court of Netherlands, the Future Generations case in Colombia, the Torres Strait Islanders victory at the Human Rights Committee in a case against Australia, and many, many others. Most of the cases and most of the analysis have focused on state obligations, but businesses also have responsibilities, and this part of the climate change litigation universe is less studied and less advanced. For these reasons, the Global Toolbox on Corporate Climate Litigation is well-conceived and well-timed. There are two other types of corporate climate litigation that I must mention. One is the rapidly rising use of claims by foreign investors using investor-state dispute settlement agreements found in thousands of international trade and investment treaties to challenge climate action. Italy was forced to pay hundreds of millions of euros because it banned offshore oil and gas exploration. Slovenia is being sued for more than 500 million euros because it banned fracking or hydraulic fracturing for natural gas. Germany and the Netherlands are paying billions of euros because they gradually are phasing out coal-fired electricity. And the regulatory chill from the mere threat of these cases has prevented states including Denmark, France, and New Zealand from going ahead with strong regulations intended to address the climate crisis. The second type of corporate climate litigation involves challenges to government climate regulation in the domestic legal system. And here, we are seeing a very positive but unexpected use of the right to a healthy environment as a shield against corporate lawsuits. Courts are accepting that governments are fulfilling their human rights obligations by enacting stronger climate and environmental laws and policies. Friends and colleagues, you have a star-studded lineup of speakers today, so I'll stop now and merely reiterate my congratulations on the launch of the excellent Global Toolbox. Thank you very much.